Good afternoon, everyone. My name is Anna Colombo. I'm a staff lawyer at Legal Assistance of Windsor. Thank you so much for taking the time to join us today, where we're going to be talking about terminating tenancies. And we have with us 3 law students. We have Princess Doe. She's a law student at Legal Assistance of Windsor. We have Sabi Ottawa. She's a law student at Community Legal Aid. And Emma Padota, a law student at Legal Assistance of Windsor. So a brief disclaimer about the presentation today is that we're providing general information only and that nothing in here should be construed as legal advice. If you need legal advice, please contact Legal Assistance of Windsor. Our phone number is here and we have additional resources that we'll be providing at the end of the presentation. So Princess, I believe it's off to you.
Thanks, Anna. So there are many students here, of course, who are currently in a lease in Windsor who have signed on to a lease for the fall, perhaps, and have potentially already paid first and last month's rent. However, with the university announcing that classes will be delivered primarily online for at least the fall for this upcoming year, many students would prefer to stay home instead of moving back, prefer to stay home instead of moving back to Windsor. So today we're going to talk about how you may be able to get out of your lease and the potential liabilities for students who are looking to end or break their lease. There's a lot of information in this presentation, but we want you to take away that there are options and that you can't just walk away from a lease that you have signed on to, and that you can get legal advice. So the Residential Tenancies Act, or the RTA, is the law that governs most tenancies in Ontario. Under the RTA, there are rules about how you can terminate your tenancy or your lease. And if you do not terminate your tenancy in one of these ways, the landlord may be able to sue you for rent owing.
The Residential Tenancies Act, or the RTA, does protect most people who rent their home in Ontario. However, there are situations where the RTA does not apply. Some exemptions include student residences or dormitories, and units where tenants share a kitchen or a bathroom with the landlord or a member of their immediate family. If you're unsure if your rental unit is exempt from the RTA, please see Part 1, Sections 5 through 7 of the Act, or visit clio.on.ca to help you figure out which laws apply to your situation and what your rights and responsibilities are. As a student at the University of Windsor, you may also contact Legal Assistance of Windsor for free legal advice regarding your tenancy. In the case of a rooming house, each tenant has a separate tenancy agreement with the landlord, and each tenant has their own room. The tenants may use certain common facilities such as washrooms, living rooms, and kitchens. Rooming houses are protected by the RTA. It is where the tenant is sharing a kitchen or a bathroom with the landlord or a member of the landlord's family that they are not protected by the RTA.
So just a note about potential liabilities for you as a tenant. If you walk away from your lease, you may be liable for the entire period of your rent, even if you do not move in. It is considered a contract that you would be breaking by you not paying the rent for the specified amount of time you agreed to. This would include fixed-term leases, such as an 8 or a 12-month lease, like many students sign on to. By not taking the correct steps to properly end your tenancy, you could face liability at the small claims court, the landlord and tenant board, or through a collection agency where you could see your credit rating negatively impacted. So to terminate your tenancy at the end of the term of the lease, you must give your landlord 60 days written notice in advance and name the last day of your tenancy. The N9 notice form is the approved form by the landlord and tenant board, or the LTB, to give this notice. And this can be found on the link provided on this PowerPoint, which once again will be available on our LAW website after the webinar today. You should keep a copy of this for yourself. It doesn't get filed anywhere, but if you do not move out on the date you agreed, the landlord can file the LTB to evict you based on the N9 form. An important note that with the ongoing COVID-19 public health pandemic, the LTB is not currently issuing most kinds of evictions.
So as previously mentioned, to terminate your tenancy, you must give notice to your landlord. The chart provided should be used as a general guideline as to how much notice you were required to give based on your rental period.
Thanks, Emma. So the next few slides of this presentation is going to focus on the 3 ways to terminate a tenancy apart from the term of your lease ending. So the 3 ways that we'll be going through is first, consent agreement with the landlord. Second, assigning the lease to a new tenant. And third, with an order from the landlord and tenant board. So an option that we actually aren't discussing in this presentation because it doesn't effectively terminate the tenancy, but it could be a viable option for those of you listening to this presentation, is to sublet the apartment. So to sublet your apartment is effectively making you the landlord of the subtenants, and your tenancy with the landlord does continue. So moving on to consent agreement from the landlord, you may ask the landlord if they will consent to an early termination of the tenancy. You should use the N11 form, which is an agreement to terminate a tenancy, and it can be found online on the Landlord and Tenant Board website. So it's important to remember the landlord is actually under no obligation to consent at all. You can make the request. However, if the landlord does consent, both you and the landlord should sign the N11 and keep a copy of the N11 form for your own records. This form doesn't get this form doesn't get filed anywhere. It should be signed by you and your landlord. But if you do not move out on the date agreed, the landlord could file with the LTB, Landlord and Tenant Board, to evict you based on that N11 form. So again, as Princess has mentioned previously, the Landlord and Tenant Board is not currently issuing most kind of eviction orders due to COVID-19. Moving on to assignment. An assignment means that you or your landlord would find someone else to take over your lease. You may assign a rental unit to another person with the consent of the landlord by making a general request to assign or a request to assign to a specific person. It is arguably your responsibility as the tenant to find the replacement tenant. A landlord can charge the tenant the reasonable out-of-pocket expense incurred in giving consent to a potential assignee. So what that means is any reasonable charge that is costing the landlord to assign your lease to someone else could be charged back to you. An example of this is the cost of a credit check. So more on assignment, if you choose to assign the unit, you should make the request to assign in writing, and it should include the following: the date, your name, your landlord's name, the address of your rental unit. For a general request to assign, request consent for the assignment of the rental unit, and for a request to assign the unit to a specific person, you should put in writing that request and that person's name. Keep a copy of anything you're submitting to your landlord for your own records. So there is some important things to consider with assignment. Tenants are allowed to assign their lease to a new person, and a landlord cannot arbitrarily or unreasonably refuse. Landlords also must abide by the Human Rights Code and not discriminate against a protected class, which includes source of income when you are finding your assignee tenant. You must give your landlord the notice of no later than 30 days after you asked if you could assign your place. So something that's very important is if your landlord refuses to let you assign at all or does not give you an answer within 7 days of your request, you can give your landlord a tenant's notice to terminate the tenancy, which is an N9 form. And that N9 form can also be found online. So important to remember, you must give that N9 form no later than 30 days after you requested the assignment. And the termination date in the N9 form need only be at least 30 days before the termination date, or 20 days for a weekly tenancy. If the landlord unreasonably refused your request to assign the unit to a specific individual, you can apply to the Landlord and Tenant Board using the A2 form for an order, either allowing the assignment, terminating the tenancy, or seeking a rent abatement. If this sounds like a lot of information and you're worried that you don't understand it completely, that's no problem. If this is a situation you find yourself in, you should seek legal advice. So the third option is applying to the Landlord and Tenant Board. You may apply for an order terminating the tenancy where there are grounds for such an order. These grounds include, first, where the landlord is in serious breach of the obligation to keep the unit in good repair. Second, where the landlord is repeatedly illegally entering the unit. Third, where the landlord's conduct has substantially interfered with your enjoyment of the unit. And fourth, where the landlord has harassed or threatened you. It's very important to remember that the Landlord and Tenant Board usually only awards termination where the conduct of the landlord is egregious and has been proven by evidence. What this means for you is that there is an extremely high threshold that you must meet in order to satisfy the requirements of this third option. So I'm going to turn over this presentation now back to Princess, and she's going to discuss canceling a lease before moving in.
Right. Thanks, Abby. So now we are going to talk about canceling a lease before moving in. As I mentioned before, there are many folks who have signed on to a new lease for the fall, but because classes are going online for at least the fall, many would rather stay in their hometowns and not have to pay rent for a space they're not occupying. So the short answer for this is to consult a lawyer. Even if you do not choose to move in, a lease is a binding agreement. You may be liable for the rent even if you don't choose to move in once again. And in this case, you should always consult a lawyer first. It is important to note that though landlords do have a legitimate claim to recover rent from you, they also do have a duty to mitigate their losses by taking reasonable steps, such as finding a new tenant first to replace you once you give them your notice that you're not moving in. Right. So apart from the ways that we have already described to terminate your tenancy under the RTA, you will also want to look to see if your lease complies with the law. If it doesn't, then you may have another way to end your tenancy. When you agree to sign a lease, you are entitled to receive a copy of it within 21 days of signing the lease. As well, it is important to note that starting April 30th, 2018, all new leases entered all new leases that are entered after that date has to be in the Ontario Standard Form lease. So the provincial government made it mandatory for all new leases entered to use the Ontario Standard Form lease, which can be found online, and there is a link provided in this PowerPoint. So a tenant may terminate a tenancy for a yearly or a fixed term lease by giving notice of a termination to the landlord using the N9 form. If they make the demand for the proposed tenancy agreement, and either 21 days have passed and the landlord has not complied with the demand, or the landlord has complied with this demand and the tenant has not entered into the proposed tenancy agreement provided by the tenant, by the landlord. Provided to the tenant by the landlord. Tenants would have to give a notice no later than 30 days after the landlord has provided the proposed tenancy agreement to the tenant. This notice needs to be at least 60 days before the date of the end of the rental period, such as the last day of the month if you were to pay your rent monthly. It is important that you make note of the limitation periods, because if you do not give the notice within the specified time frame, then you would not be allowed to give your early notice to terminate anymore. So notifying the landlord as soon as possible. As soon as you know you want to break the lease, we recommend notifying the landlord as soon as possible in writing. The landlord is allowed to consent to canceling a lease. You can come up with another alternative arrangement with your landlord, for example, such as a reduction of rent while you're not living in the unit. Your landlord is under no obligation to make an agreement like this. So some students who have signed on to fixed term leases, such as an 8-term lease or a 12-month lease, have made arrangements with their landlords to not pay rent for the fall semester and start paying rent in the second semester in January, for an example. As well, some people have made temporary arrangements with their landlords to maybe even pay half the rent, like I mentioned before. Once again, the landlord is under no obligation to make this agreement, but parties do have an option, and this can be a creative solution for some. If you and your landlord do come up to this agreement or do come up with an agreement, put your agreement clearly in writing and seek legal advice if possible. So a tenant who unilaterally decides to not move in and cancels the lease is generally not entitled to get their last month's rent deposit. However, if you are in this situation, we do recommend getting legal advice first. If the landlord does not give you your last month's rent back and you wish to challenge this, you would need to pursue action through the landlord and tenant board using the T1 form. Other deposits such as damage or pet deposits are not legal, and therefore you are entitled to receive that back. As a reminder, the rent deposit should be no more than a 1-month rental period. Furthermore, deposits for keys are legal, but they are automatically refundable, and you are also entitled to receive this back. Tenants have a 1-year limitation period to bring an application to the LTB to get their last month's rent back. This means that if it's more than 1 year after the deposit should have been returned, then the LTB will not hear your case. So it is important for all tenants to keep in mind this limitation period.
It can be difficult to determine what your rights and responsibilities will be when sharing a rental accommodation with other people. There are many different kinds of arrangements and different ways the laws will apply to them. Generally, a joint tenancy is a situation where you and one or more people have rented a place together as a group, all under one tenancy agreement with the same landlord. In a joint tenancy, you are jointly and individually liable for the payment of the entire rent for the rental unit. This means you're responsible for the entire rent of the place if the others do not pay their share of the rent, unless you specifically agree otherwise with your landlord. A tenancy in common is a situation where you and one or more people are living in the same rental unit, but each have a separate tenancy agreement with the landlord, even if all the tenants have signed one tenancy agreement. If you are in a tenancy in common, you are only responsible for the payment of your share of the rent. If you are in a joint tenancy and you and your roommates want to move out of a unit, you can give proper notice to the landlord together to terminate your tenancy by all signing an agreement to terminate a tenancy with the landlord using the N11 form, or by giving the landlord the tenant's notice to terminate the tenancy using the N9 form. If only one person wants to move out, they may continue indefinitely to be liable for rent and other obligations. It is best if the person leaving can reach an agreement with the other co-tenants and the landlord. You may also request an assignment of the tenancy from you and your co-tenants to your co-tenants and the new tenant. If you get permission to assign the lease, a release should be signed between you and the landlord. A release is a new agreement that relieves you from all of your obligations to the landlord. For example, a signed release would protect you from having to pay rent if the new tenant did not pay. If you are subletting, you are still legally responsible for all of the obligations under the lease and under the RTA. For example, if your subletter fails to pay rent, the landlord can collect unpaid rent from you. The rules around joint tenancies and tenancies in common can be complicated, so it's best to seek legal advice when ending, assigning, or subletting your share of the rental unit if you have roommates.
So before we end off the webinar today, we just wanted to make a note or bring something to your attention about a new piece of legislation that the provincial government is currently reviewing. So the new Ontario Bill 184, if it were to be made law, would change the process of how landlords collect arrears or rental arrears from past tenants. So currently the landlords have 2 years to pursue rental arrears from former tenants through the small claims court. But if this bill passes, landlords would now be able to go through the LTB, or Landlord and Tenant Board, within 1 year to recover rental arrears from those who have moved out, which would arguably make this an easier and quicker process for landlords to sue. But no matter these changes, if you do get any documents from your landlord about rent owing, either from the small claims court, the Landlord and Tenant Board, or a collection agency, we do recommend getting legal advice and participating in the legal process. Otherwise, decisions might be made against you. So we'd like to thank everyone for coming to our webinar today. This is the end of the presentation. We do have a list of resources that will be, as you can see here, posted in the link in the PowerPoint, so that you can access and learn more about your potential situation and hope it gives you further direction. As we mentioned in the beginning of the presentation, there is a lot of information, but what we want you to take away from this is that there are options that you can't just walk away from a lease that you have signed, and that you are able to get legal advice. So, and now we'll open it up for questions. Is this recorded? I believe so. Anna, can you speak to that? It was recorded?
Yes, so it is being recorded, and we are going to attempt to post it on our website, legalassistanceofwindsor.com.
And like we said before, the PowerPoint will also be posted, so you can get access to those links.
And so please, if anyone has any questions or any issue in their own situation, please do not hesitate to contact Legal Assistance of Windsor. So does the limitation period suspension impact how many days you need to give your landlord notice in an N9? That is an excellent question. I don't believe it does. I think the limitation period it's with respect to filing documents at the Landlord and Tenant Board. So if you had, let's say, your 1 year limitation date coming up to file to get a last month's rent back or an illegal charge back, that is currently suspended, but you would still need to provide the proper 60-day notice to the end of term, or the 30-day notice if you're using that assignment loophole. And so someone else is asking, they haven't officially renewed or signed their lease, but they've been paying rent. And so are they technically in a binding lease? And it's a 1 year lease. And so when a lease is coming up to the end of that 1 year term, there's actually no need to sign a new lease or to renew your lease. It automatically renews on a month-to-month basis. And so what that means is where you would have had to provide that 60-day notice to end your lease, and that 60-day notice would be that last day of that fixed term period, you then move into month-to-month. So then your 60-day notice could then be 60 days to the end of the month. It's not another year. And so someone else is asking, so they have a regular 12-month lease with their landlord. If by mutual consent we decide to cancel our lease, what kind of release should we sign, and is there a specific form? So if you decide to cancel your lease, if you want to end your lease, then you and your landlord can do that using that N11 form that we discussed earlier. And all of these forms can be found on the Landlord and Tenant Board website. That N11 form would have all of that information that you would need to include in there. I'm not sure if there's an option for audio questions, but certainly please type your question and we will answer it. Any relief or legislation coming down from the government to help students get out of lease agreements if classes are not in person? Not that I'm aware of, no. The only legislation that I'm currently aware of is Bill 184. So there's nothing that I'm aware of specific to students, given the fact that circumstances have changed significantly, and no financial assistance that I'm aware of either, unfortunately, other than the student, the emergency benefit that's available for students. And is LAW able to help students if there are any issues in the fall or the winter? Absolutely. We are open year round, and we continue to take calls, and we continue to provide advice and speak with clients over the phone. And so please call our office at any time, and we will do our best to assist. And even if it's an issue that we can't assist with, we can always provide referrals. So please do contact our office. So someone has asked that they moved out of their apartment before the lease was up, notified the landlord a few days before they left that they had to leave and couldn't afford to continue to pay the rent. So can she sue you for the 2 months rent? So without providing advice specifically to your circumstance, in general, if you move out without providing that proper 60-day notice, then you could remain liable, and your liability, if you're on a month-to-month lease, could be that 60 days to the end of term. If you were in the middle of a fixed term tenancy, so let's say you're only 3 months into your 12-month lease, in theory, you could be liable for those full 12 months. But again, as was mentioned earlier, the landlord does need to mitigate their loss. So they have to, on their end, look for a new tenant. So can the landlord make assigners liable for their proposed assignee? Arguably, no. Once that assignee takes over, that new tenant has stepped into your shoes, and so your liability for the tenancy ends. So you would not be liable for that new tenant's behavior. You would not be liable for that new tenant's failure to pay rent. And so that's what makes assignment preferable to subletting. With subletting, and that's where you're leaving, but you intend on coming back. And so in a subletting situation, you are liable for your subletter's behavior, and you are then liable for your subletter's failure to pay rent. If the landlord is not ready to terminate the lease, is there any other way to terminate the lease? I would recommend going back through the slides and going back through this presentation, because we've discussed a number of ways to terminate the lease, whether it's notice to the end of term, whether it's through assignment, through an order from the board, or looking at whether you've got your documents, your lease in the proper document. If you want further legal advice about that, please contact our office, and we can certainly go through your options in your specific situation. So would a place like Canterbury College be covered by the RTA? They have both student apartments and student housing. That's an excellent question. My understanding is that it is not covered by the RTA, but I would recommend getting someone to look at your specific lease agreement, getting a lawyer to look at your specific lease agreement, and getting legal advice around that. But if it is a student residence, then it's not covered by the RTA. And so someone's asking, so to clarify, do you need to give the 60 days notice before the end of the lease? So if the lease ends July 30th, do you need to give 60 days notice before, or can it be less given that the lease is already coming to an end? No, if you're in a fixed term lease and your lease ends for July 30th, then you still need to give that 60 days notice to terminate. Just because it says this is the last day of the tenancy, it doesn't mean that you can simply walk away at that point. You need to give your 60 days notice. Otherwise, it's going to automatically renew on a month-to-month basis. No one else needs to do anything. No one else needs to sign anything else. It automatically renews. So please do make sure to give that 60 days notice. So for today's date, for example, today's June 11th, the earliest that you could terminate your tenancy with 60 days notice would be August 31st. That's giving you that full 60 days to the end of the term. So someone's saying that they've already given their landlord the written form without using the N9. And that was on WhatsApp before 60 days and a written form through email before 30 days, and even the condition of the basement is not good. And he did not agree, and so then you moved out. Now you have an N4. So the N4 notice is the first step in the eviction process. So I would suggest if you do get anything indicating eviction, please do get legal advice so that you can understand more fully what that means for you in your situation, especially since you've now moved out. So yeah, so I would please get legal advice about that. Can the landlord refuse to return the security deposit you paid in these circumstances? It really depends on what you've paid, whether you've moved out giving proper notice or not, whether you've moved into the rental unit, what's in your tenancy agreement. There's a lot of factors to determine about whether you can get it back. And so if you aren't sure about whether you can get it back, again, please get legal advice because there are a lot of factors to consider. Can you get information on how to contact for help or for emails and the contact number? So at the end of our PowerPoint, we do have a list of resources with websites available. Legal Assistance of Windsor is listed there, as is Community Legal Aid. So please go to our website. Our phone number is 519-256-7831. And certainly you can call us and speak with our intake worker. So another question, if by mutual consent you decide to terminate your lease, do you need to give notice in advance? So no, if both the landlord and the tenant are agreeing to end the lease, then they simply need to sign the N11 form. That would be my advice, is both parties sign that form, keep a copy for your records. That discussion could be had at any point, and you can come to an agreement for any date that both you and the landlord are agreeable with. Someone's asking, because the university is teaching online, is there a policy that could help you end your lease early? So again, I would refer back to the presentation and refer back to the slides. And if you continue to have questions after that, if you're not sure how this applies to you or whether you're taking the correct steps, then please call our office and get further legal advice about your specific situation. The law hasn't changed just because the university is teaching online. The laws around terminating your tenancy are still the same, and so you do still need to follow the proper steps when you are terminating your tenancy. And so we're going to post the slides on the website, I believe, legalassistanceofwindsor.com. And so you will be able to find them there in the coming days after this presentation. So it looks like those are the questions for now. So again, if you have questions specific to your circumstance, then please do contact Legal Assistance of Windsor, and you can look at getting further legal advice from there. If you're not sure if you need legal advice, you can still contact our office. The situation, consulting a lawyer, it doesn't have to be dire in order to access our services. You can call us with these questions, and we can see about getting the appropriate advice and appropriate information to you. So thank you so much for everyone for joining us today. I hope that everyone's able to stay safe and stay healthy, and that's it for us for now. Thank you so much, everyone.